Hi, everyone. Harry here. So, not surprisingly, we are off to the races to try to delay things. That is, Donald Trump wasted no time from the issuance of the immunity decision to file a motion before his favorite judge, at least among those presiding over criminal cases of him, Eileen Cannon, saying the immunity opinion really requires some changes and poses significant problems and the like. And he also said there are certain motions and matters like discovery that you need to put on hold until you do decide the upshot of the immunity motion. Now, he asked for, and Cannon agrees. So she's now put 3 or 4 pending motions on hold and set a schedule for Trump to explain why the immunity decision should make a big difference, the U.S. to rebut it, and then a reply. Trump had said, let's go till September. Cannon didn't give him all that, gave him to July. But remember, this case consists almost entirely of post-presidential conduct. This is stuff that he spirited out of the White House and then absconded with and kept from the authorities. 15 months of footsie with the archives, and then subpoena, and then finally the search warrant, all of which he is former President Trump. So why does he think he's going to get a big bounty from a case that holds when and how you can bring criminal prosecution for acts done as president? Well, basically, why not? We'll see what he can make of it. There is going to be potentially some action involving the final hours while he's in D.C. and is still president. That's when he may, let's say he claims he declassified everything, and the court has suggested you can't look into motive, maybe can't look behind it at all. How does that sort of fact even get rebutted by Jack Smith? So there's no doubt that even though the Mar-a-Lago case of all the cases involves the least presidential conduct, it's a loaded weapon that the court has constructed for any judge to use, and who better than Eileen Cannon. But they're shaping up to be 2 specific issues growing out of the immunity case, as I see it, for Trump. First is, you may have noticed, there was a lone dissent in that case, by concurrence, I guess, in that case by Justice Thomas, saying the special counsel was illegally appointed. This is a really out there theory, and one that has been, adopted by some graybeards in the conservative movement, but has been repeatedly rejected in the federal courts. That doesn't matter at all to Justice Thomas, who loves idiosyncratic and much rejected theories. And there's every reason to think, and at least it's consistent with what the hell's he doing with this separate motion. It seems like a kind of blueprint for his friend and fellow in arms down in Mar-a-Lago. This will be something that they will press hard to say Justice Thomas had it right. And if you're Eileen Cannon, Justice Thomas's endorsement might be worth more than the rest of the legal world's rejection of it. So that's one thing that's going to come up on immunity. Then, in some ways, the most kind of sneaky or worrisome feature of the whole Supreme Court opinion, and one which they explained not at all fully, and this is going to matter in the Manhattan case as well. The court goes through all its reasons why you cannot criminalize or try to bring a criminal prosecution based on official action, but rather just unofficial action. And then it adds, with not much reasoning, as if it just follows, Of course, since you can't do that, you also can't use evidence of an official action to try to prove an unofficial action. And why not exactly? Remember, the theory of the case for immunity is it's hardly constitutional. It's just what the conservative six think of as good government. But to have the president aggressive and nimble, etc., why the fact that some piece of evidence might later be raised on an official act? Most evidence is public. Most official acts are. And how that fits into the scheme, we don't know. But man, is it going to be a headache? Because let's take Manhattan for starters. There were a few pieces of evidence introduced in those convictions, most notably Hope Hicks's conversation in the White House with Trump, which may qualify as official actions. And if you can't use those to prove the unofficial action and paying off a porn star to hush money to affect the election before you've been elected seems as unofficial as it gets. But if you couldn't use that as evidence, it might be that a court would say you need a new trial here. Now, it might not be for a few reasons, including that there's enough evidence without it, so-called harmless error. But it is a tricky sort of time bomb that's just in there. Likewise, now come back to Mar-a-Lago. There is now the possibility of hand-to-hand combat over any number of pieces of evidence that they might want to use from Trump's presidency, which would show, what he's doing, why he's doing it. Another topic that is off limits. We don't look into the motive for official action. So there may be many pieces of individual evidence that they can now persuade Judge Cannon have to be removed from the case. And that is A, a headache for the case itself, and B, a potential nightmare of a thicket of long-standing trying to get it all straight with Eileen Cannon and in advance. So that aspect and that particular point of the Supreme Court, no evidence even of official action to prove even an unofficial action, which therefore may be criminalized, is going to give rise to a lot of mischief going forward. The opinion, I think, is overall an atrocity, sort of constitutionally as a matter of principle, but also practically. And in terms of its practical headaches, this is the double migraine of them all, and one that the court seems not to have fully thought through. So combine that with the enthusiastic hands of Judge Cannon for Donald Trump, and even if he loses the election, we are potentially way upriver teasing out the implications of the immunity opinion for quite a long time. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.